Hello, again. This is Daryl Miller with Parole Advocates. I'm going to go over a summary of information that the Parole Board or the examiners can consider. The Parole Board examiners can consider any mitigating or aggravating circumstances of a crime. Mitigating circumstances are circumstances or information or situations that basically state that the situation wasn't as bad as maybe as it may have been purported to have been. Example, a person may have been convicted of aggravated assault, but the aggravated assault may be merely by pointing a gun at someone versus having shot the person. A person may be convicted of theft, but the property that they stole was not actually taken from the store, but maybe hid or shielded from the store being able to see it. Basically, they concealed it. And they may have actually concealed it and put it back on another shelf, but because it was seen that they did conceal it at some point, the person may still have been convicted for that. So circumstances that present that the person's conduct was not as bad as the crime alleges, those are circumstances that are considered to be mitigating. Aggravating circumstances are circumstances by which they state that this situation was a very heinous or bad, or it affected people who are vulnerable, whether it be young people or older people, someone who was uneducated. That, in other words, someone took advantage of someone, and the court may see fit to, or the parole board see fit to punish the person even further by requiring they do more time on that sentence than normal. Aggravated circumstances can also be coupled with or added on by the attitude or the statements made by the convicted felon at the time of their arrest. The person makes statements as to whether the person had it coming, or that it was in revenge, or that it was for pay. These are also factors that can be considered to be aggravated circumstances. Further, out of the things that the parole board can consider, they can also consider statements on behalf of victims. It's not uncommon that the parole board will stay in contact with the victims throughout the duration of time that the person who's serving time is actually serving time. They send out letters every time the person comes up for parole, and the victims can reply and send in whether or not they believe or feel that that person who perpetrated the crime on them should or should not make parole. In addition, community letters of support for those who have supporting community or those who were witnesses to the crime, they can make or submit statements to the parole board, and those statements can be considered by the parole board as to determining how much time that person should or should not serve. Reports and statements on behalf of the counselors, the wardens, and anyone that comes in contact with the inmate can be also presented into the inmate's file as to whether a person makes parole or does not make parole. We've seen cases where a person was actually in the process of making parole and made an inappropriate statement at the warden at the time they were getting ready to be released, and for the warden to communicate that immediately to the parole board and for that person to be pretty much sent back inside of the prison, and for them to have to take the clothes off that they had in their preparation to being released, that they have to actually end up going back into the prison system. So these are some of the things that are factors as to what can be considered by the parole board when they're being considered for parole. The inmate statement can be considered as to whether they're still innocent. It's not uncommon that the parole board will take consistent statements of the person being innocent as failure to accept responsibility for the conduct that led them to end up being in prison. That conduct is conduct that is seen as being a part of the process of them not rehabilitating themselves or working towards rehabilitating themselves. These are some of the things that can be considered by the parole board as to whether a person makes parole or not. There are other additional factors that can be considered. For more detail, you can contact us by emailing us at theparoleadvocates@gmail.com. Again, theparoleadvocates@gmail.com, or calling us at 404 855-4569. Also state that we're not lawyers. We do not purport to be lawyers. Any statement that can be conveyed as being legal advice, please disregard that information. Thank you in advance for attending another Parole Advocates seminar.